Welcome to the commemoration of the opening of the 2021-2022 law term of the Supreme Court of Judicature. Please join us for a prayer by Pandit Lloyd Mukram Serju, President of the Inter-Religious Organization of Trinidad and Tobago.
Let us pray. Almighty and eternal, highest on high, the light of the world, the merciful, compassionate, caring and loving Creator, we seek your divine presence amongst us as we commemorate the opening of the 2021-2022 law term. Bless the Chief Justice, the judges, and all connected with the administration of justice in the country. We ask you to guide and protect them all. Continue to give them the health, strength, and vision to do all things right to the satisfaction of our nation. Show them the path of righteousness, so that they will be guided in their judgments and decisions. We ask you to also bless their families and members of staff. You are ever present in all our relationships. You are the remover of sorrow and the bestower of happiness. May your divine light continue to shine over their places of work for safety and protection, so that they can perform their duties without fear or favor. Merciful Creator, we seek your forgiveness of any mistakes that may have been made in the past. We give thanks for all that you have bestowed upon us and seek your eternal presence. Bless those who have served this institution and are not with us today. May your light continue to be with them now and in the hereafter. May we all receive comfort and solace in your love, powers, and light. We thank you.
We thank our inter-religious organization. It is our pleasure to introduce Kishon Julian, winner of the 2021 Panorama competition.
Good day, fellow citizens. Some of you may recall that during my inaugural speech as Chief Justice, way back in 2008, I likened the judiciary to a business corporation and the citizens of Trinidad and Tobago to its shareholders and customers. It was a deliberate paradigm shift because I recognized that a change in philosophy and culture was a necessary ingredient for meaningful and permanent transformation. As I reiterated in 2010, and I quote, "What we have been trying to do is not just to put physical systems and procedures in place to dispose of cases, but to do so in a philosophical and psychological context that is grounded in the notions of service, accessibility, and accountability. We believe this should be the minimum return on the investment made in us by our shareholders, the national community, especially when what is invested is their trust and their confidence. That approach also leads us to pay attention to cost effectiveness. It requires us to look at the subjective customer experience and not just throughput rates. It requires us to develop an organization that exists not for self-perpetuation, but one that anticipates and responds flexibly and proactively to a changing external environment, including, most importantly, its customers' expectations. Otherwise, that part of our vision that speaks to maintaining public confidence in the administration of justice would be a mere platitude." End quote. Today, I bring you the Chairman's report. Walk with me as we briefly revisit our journey over the past decade. We will see the steps taken toward the fulfillment of the vision, the work that has been done over the past year, and the projections for the coming year. Remember the theme, people, plant, and process, as we trace the path of transformation through focus on process reengineering, physical and digital infrastructure, and technical and human resource realignment. Where were we in 2010? We were operating in a paper-based environment. Our legacy case management software, GEMS, was prohibitively expensive, not well supported by the vendors, and no longer meeting our evolving needs. Our organizational structure did not adequately take account of the diversity of our customer base. Just to give a few examples of the steps on our journey. First, we recognize that drug addiction is a public health issue with criminogenic dimensions and not just a crime problem. So the drug treatment courts were established. Secondly, the criminal justice system treated children in conflict with the law like adults, not recognizing their neurological and psychosocial differences and needs as criminogenic factors that required differentiated treatment if the aim is restoration and reintegration into the society. We partnered with the UNDP and USAID as well as local stakeholders to transform the juvenile justice system up to and including new judges' rules for children. Thus, the Children Court was born, providing a specialized suite of diagnostic and support services. We finally got rid of the awful concept of children beyond control. We now speak of CHINs, children in need of supervision. The new nomenclature suggests a change that is both attitudinal and ameliorative rather than derogatory. Thirdly, new criminal procedure rules were introduced to assist in the proper management of criminal matters. Fourthly, systems for collection and disbursement of maintenance and payment of fines and fees were paper-based, requiring physical attention with lost productivity for the judiciary and clients alike, and did not take into account the fact that a large percentage of our population is unbanked. And so, court pay was born. As I mentioned last year, it is about more than payments. It is about e-vote books, generation and reconciliation of accounts and reports, and better audit trails and accountability. All this on our own in-house proprietary software. There is now an additional version of court pay, bringing more convenience to our customers. Fifth, with Nigeria and the National Center for State Courts, we formed the nucleus of a consortium to develop case management software with no licensing costs. That consortium has now grown to the extent that 22 interested countries were represented at the consortium meeting in early October, with Namibia being the latest to formally join. We will continue to benefit from innovations and improvements developed in any of the member countries, and TT Jim is now into its second iteration, thanks to that fruitful collaboration, whose product is on its way to becoming the gold standard internationally. Lastly, the divisionalization of the High Court and reducing the number of districts in the Magistracy can now facilitate more focused management and efficient deployment of human resources. During the course of today's presentation, we will highlight some of the major achievements and reforms that we continue to roll out in fulfillment of our mission. Suffice it to say that by the beginning of 2020, we were well poised to transition the judiciary to a place where we could leverage the best available technology in support of more rational, streamlined, and effective workflows and processes. And then there was COVID-19. Crises present both incentive and opportunities for change. In order to maintain service delivery, some priorities were reordered and timelines advanced. Guided by our medical response team in the preservation of a safe environment and development of new protocols for court users, staff, and facilities management, we have made the transition to e-delivery of justice quite successfully, and the expectations and desires of our clients have now shifted toward full acceptance. This is the new normal. Our most recent development, of which we are quite proud, is the rollout of our Judiciary Contact Center. It is much more than a call center, providing live assistance and opportunities for problem solving for whoever needs to navigate our systems. The center will move towards the increased use of information technology in the future to meet stakeholder needs. We recognize the need to be more user-friendly, particularly in an environment where our clients cannot simply walk in for guidance as the pandemic continues to affect us all. And in any event, why expend on and risk transportation when you could do it from home? In terms of stakeholder engagement, we have restarted the Criminal Justice Sector Committee, activated the Domestic Violence Process Review and Service Enhancement Committee, the Accelerate Restore Connect program, ARC, with COSTAT, the U-Turn collaboration, and the TTICCS Codes Multi-Stakeholder Committee, to name a few. This is not by any means to suggest that everything is perfect. While we have been able to sustain an acceptable level of productivity, significant challenges remain, such as the inability to conduct jury trials because of the severe logistical problems associated with social distancing and sanitization. Last year, I had to point out that despite all our efforts, the reality of the COVID-19 pandemic for half of the year had an inevitable impact on our output. Little did we imagine at the time that we would have to experience a further full annual cycle under severe constraints. To be able to maintain and in some areas increase total disposition figures is a remarkable feat. In the Civil Division of the High Court, we actually disposed of 3,025 matters, a marginal uptick from last year. Of particular significance is the fact that 74% of those matters were less than 2 years old at the time of disposition. The news was similarly encouraging in the family jurisdiction, where there was an increase from 2,555 to 2,688. And I am happy to report that 72% of those were less than a year old. Owing to the absence of juries, the situation was more challenging in the criminal jurisdiction, but we did manage to complete 30 matters, including 8 murders. The criminal division will be receiving focused attention this year, as the logistics of providing enough large, sanitized and socially distanced courtrooms for jury trials is likely to be a problem for some time. For the next few minutes, we will share some of the more significant developments that have occurred since my last address. In keeping with the ethos of Team Judiciary, I will take a back seat and return a bit later, as I first let some team members share their experiences. Thank you for your attention during this time.
The Court Executive Administrator, or CEA, heads the Department of Court Administration, which is the administrative arm of the Judiciary and reports to the Honorable the Chief Justice.
Courts are complex organizations in which many moving parts must come together for individual cases to be heard and for all cases to progress. Each of these parts require resources, systems, and processes, all of which must be designed, implemented, and managed. It's a tall order, as just over 150,000 new cases are filed each year to be heard by 111 judges, masters, and magistrates. And all activities in these cases must be signed off on by 19 High Court registrars and 17 Magistracy registrars. To the individual user, what is seen is the simple scheduling and disposition of their case, the service that we provide to them. Aware of the fact that the judiciary's role is to provide a service to the public, we set about to review and transform the judiciary's structure, resources, and processes to address modern realities, identified weaknesses, and to improve its service. Although technological solutions had been used for some years, in 2017, we embarked on an organization-wide e-strategy to address the myriad systems which hindered our service delivery. Using our own internal resources in the main, the organization continued expanding its use of technology to develop a suite of e-services to eliminate waste, increase efficiency, improve access to justice, reduce delay, and support case management. Efforts were spent on, among other things, digitization of records such as probate, court files, pay record cards, accounting records, maintenance cards, human resource management records, and correspondence. On new case management information systems, on remote hearing technology, digital voice writing with audio digital recording, e-payment systems, closed-loop email systems between courts and attorneys, e-signature technology, process mapping and workflow redesign, process reengineering, the judiciary's wide area network and its cloud. While we had been making significant headway, the onslaught of a viral pandemic hurled us onto the speedway of implementation. Our preparation and agility enabled us to immediately put as our driving strategic goals continued access to justice and the safety of the public and our staff. Several solutions that we had in the works, but for which we had planned a kinder and gentler introduction, were rolled out almost overnight. We asked you to change how you engage with us, and with some understandable concern, you did. We now have full virtual hearings about to be further enhanced by the use of case presentation software. We have payments being made electronically and documents filed online. We have better communication systems and document transmission. Several attorneys commented on the convenience that virtual hearings have brought. They are pleased that they can appear at different courts in the country on the very same day, reducing the need to ask for adjournments. They appreciate not having the downtime of waiting at a courthouse for their matters to be called, and not having to drive to location, find parking, walk to the courthouse, and wait. Those who have done more full trials have also said that with practice, they're getting the real hang of it. Many attorneys who initially expressed displeasure with the arrangement subsequently indicated their support after participating in virtual hearings. They tried it and they liked it. It has also allowed both lawyers and the public to file documents and make payments without concerns about the closing time of court offices or traveling to specific locations. For members of the public without digital resources, provisions were made by kiosks and virtual access customer centers. It has all brought greater convenience and better access to justice. It has also kept us a bit safer at this unprecedented time. Combined with these strategies, structural changes also enable us to bring more focused management, improved processes, and a better use of resources to the task at hand. We know that for many, no improvement is worthy of recognition until the backlog and delay are reduced. And that may mean until their case can be addressed quickly. We recognize this. All of this that we are doing are the building blocks necessary to reduce backlog by systematically putting the fixes where they are actually needed, not just where anecdotally it is thought to be needed. This is why we need case management information systems and data and workflow analysis, why we need digitization and digitalization, and the right resources properly managed and assigned. If any of those many moving parts are not properly designed, implemented, or managed, your case can be affected. We are addressing the moving parts that we have responsibility for and trying to work with those agencies and persons who have responsibility for the other parts. So yes, we all have to do things differently. Change is happening fast, and we have to be resilient. The President of the United Nations General Assembly, Volkan Bozkır, has called on us all to increase our resilience. Invariably, The fulcrum of resilience includes self-awareness and a sense of purpose, letting go or embracing change and connections. These make the difference and allow people, organizations, and nations to overcome.
Mrs. Wendy Lewis Callender is the Deputy Court Executive Administrator, and she shares with us some of the work of the Family and Children Division.
This law term was testimony to the resilience and dedication of our staff and judicial officers in the Family and Children Division, who, despite the many challenges of the pandemic, steadily pushed ahead to further improve our systems to ensure that our customers continue to have access to the courts. As problem-solving courts, our wraparound services and programs are critical to the families and children that we serve, and these were adapted to the virtual environment. This required staff to hold the hands of our customers through virtual spaces to ensure access. Between the family and children courts, over 21,000 virtual social service interventions were conducted. We've also focused on processes to improve how we treat with customers affected by domestic violence. And to provide greater access to the court, we implemented a domestic violence hotline and email system which supported over 4,500 customers. Judicial officers and staff and our justice sector partners were also trained in the handling of domestic violence matters. A third family court was established in Princestown, and the family court in Port of Spain expanded to ensure families in these jurisdictions received improved services and access to a family court. Together with our colleagues at the district courts, we intensified our efforts to convert over 9,000 customers to court pay to allow for easy access to maintenance funds. We recognized that the children who come before the court lack transitionary support. Judiciary has therefore developed the Accelerate, Restore, and Connect program and will partner with COSTAT to provide these children with opportunities for mentorship, coaching, academic and skills development, and career growth. Electronic monitoring was also introduced at the Children Court as another non-custodial option for children. This just gives a snapshot of our work, dedication, and journey as we continue to provide the necessary support for families and children.
The Criminal Division has been undergoing much change in preparation for the implementation of new legislation. Madam Justice Ramsumir Hines and partner Master Trevor Jones give us some insight into the new landscape.
I am Justice Lisa Ramsumir Hines.
I am Master Trevor Jones. As partner master, I case manage the judge's calendar robustly. Not every indictment requires a trial, and I can fast-track matters to the judge using early disposition tools, such as plea bargaining, guilty pleas, still less accounts, and maximum sentence indications. For trials, I narrow the issues to only what is in dispute.
Once I get a trial-ready matter, I then manage it to disposition like a project. More persons are electing judge-alone trials and have come to realize the efficacy of the virtual courtroom. In virtual judge-alone trials, attorneys, accused, and anyone else in remote attendance can simultaneously observe every single word and item of evidence together with the fact finder, who then returns a verdict with reasons.
The outlook is even better as we are now using case lines for trials.
Case Lines is litigation support software that facilitates paperless access to uploaded trial bundles and affords advantages in preparing for and navigating evidence. For example, just imagine, even in a jury trial, the efficiency of an automatic page direction to the relevant photograph or specific timestamp on CCTV footage.
Judges and masters cannot do it alone. If all stakeholders embrace this virtual reality, as the rules expect, we can make sensible use of the judicial air.
and deal with cases justly.
Transformation of the judiciary has also included the creation of new positions to strengthen the administration of the judiciary. Magistracy Registrar Diana Reinsing and Court Manager Sankar of the Court Administration team tell us some more about it.
As a Magistracy Registrar
and a District Court Manager,
we represent significant change in the Magistracy. The Magistracy Registrars are newly introduced judicial officers who provide legal services to the Court Office of the District Courts. This has relieved magistrates from significant administrative responsibilities such as being the keeper of the record and ensuring Court Office action is in accord with the law. They have now been able to direct their attention to effective case management and timely disposition of matters. Aside from undertaking these administrative responsibilities, we as Magistracy Registrars are also justices of the peace. We play a pivotal role in ensuring that self-represented litigants are properly guided.
as District Court Managers, we bring to each court location a level of management that had not before existed. We have therefore been implementing policy, procedures, and practices to ensure consistency across the magistracy and to ensure that consequential activity, such as criminal committals, fines and fees administration, as well as records and process management, meet the standards set. We bring human resource management and location management, among others, to the individual location. Recently, the many magistrate court locations were consolidated into 3 magisterial districts. This provides greater opportunity to consolidate resources, avoid unnecessary duplication, and focus the management of our caseload.
The advent of virtual court hearings now provide an opportunity for a single magistrate to hear matters from several locations in a district, thus maximizing their effectiveness. These are but a few of the many changes at the district courts that are designed to help us better serve you.
The Civil Division was recently established and is soon to be relocated to Tower D of the International Waterfront Complex. Deputy Court Executive Administrator J.B. Filbert shares with us some news on the new division.
The Civil Division of the Judiciary includes the Civil High Court, the Probate Registry, and the Petty Civil Courts. The Civil Division Administration Department is the administrative arm providing strategic direction for and oversight of the division and its operations. The law term has been a year of continuous progress, learning, and development. The division has made strides to becoming a modern, customer-centered environment where court services are delivered in an efficient, effective, and accessible manner. During our initial year, the department facilitated virtual dialogue sessions with various stakeholder groups to discuss the establishment of a small claims court. We implemented e-filing portals for the Petty Civil Court and the Probate Registry, and further reworked strategies and processes with a view to promoting value-added activity and working towards improved quality services to our customers. I'm also pleased to report that development work has started on the new automated case management information system. The TT-GIM Civil module will replace outdated software and assist the division in case management while contributing to improved statistical reporting. These more modern approaches to handling civil matters will redound to the benefit of our customers and stakeholders. The learnings from the last year will play a critical role in shaping the way forward for the division. We will continue to collaborate with stakeholders to encourage the use of alternative methods to resolve civil disputes, among other things. Draft mediation rules have been sent to the Rules Committee in this regard, and infrastructure is in place to guide the process. Probate reform will continue to be a high priority for the division during the course of the year, and we look forward to the introduction of the Small Claims Court in Trinidad and Tobago. In sum, re-engineering through process reform, modern approaches to court management, and the use of technology will continue to be our focus. We look forward to improving the quality of civil justice and the continued transformation of the judiciary of Trinidad and Tobago.
During the last law term, measures were also adopted to strengthen and modernize the judiciary's financial management. Jerome Mark, Deputy Court Executive Administrator, shares with us some of these measures.
Accountability for the financial resources entrusted to its care, more specifically the collection of state revenue, the expenditure of funds appropriated by Parliament for its operation, and the trust funds it must hold, is also important to the judiciary. The court pay system, an integrated electronic court payments solution to receive, disburse, and account for all monies paid into and out of court, makes it simple, accessible, fast, effective, and reliable. With the inevitable shutdowns due to the pandemic, our strategic goals became continued access to justice and safety of our customers and our staff. This demanded in the 2021 law term the expansion of the court pay system to allow all customers to make all payments online. We are pleased that court customers are able to pay a court-ordered fine or a fixed penalty notice, whether it is a public health or mask ticket or a traffic ticket issued prior to May 26, 2020, using our online facility with either a credit card or Visa-enabled debit card. The judiciary continues to advocate for the use of court pay vouchers for court customers who may not meet the requirements to open and operate bank accounts and therefore must pay in cash. The Ministry of Finance should approve this additional option soon. It is noteworthy that the court pay voucher system continues to work successfully for customers making payments for court-ordered maintenance since its introduction in April 2018. The judiciary now collects, reconciles in advance, and remits to the Treasury daily via automated clearinghouse all state revenue collected online. The electronic vote book, a bespoke contract management, invoice processing, and supplier payments system, was fine-tuned and new features developed in the past year. While the automated system operates alongside the established paper-based system, we hope to convince the relevant state agencies to approve its use as a replacement for the antiquated, manual paper-based financial management and records-keeping system by the end of the 2021 calendar year. The automated financial information management software is fully designed, developed, and maintained by our in-house information and communication technology staff and is compliant with the Public Service Financial Rules and Regulations. The system facilitates online processing of statutory and contractual payment obligations, produces on-demand customized reports on these obligations, and alerts the organization about the financial resources required at specific periods during the financial year. This removes the current limitation of access to paper records during normal working hours. This complemented our work-from-home strategy during the COVID-19 pandemic. So far, we have shared the software with one government ministry that was interested in exploring its functionality in the 2022 financial year.
Cindy Ramsuk is the Court Information and Communications Technology Project Manager. And today on our program, she gives us an oversight of the court's technology thrust.
With the development of an e-strategy, the need for a formalized project management office unique to ICT projects became necessary and was formed. The ICT PMO is currently managing 50 projects which all involve development and/or networking infrastructure, and are all but 2 being implemented by Judiciary ICT staff. Those which are being implemented by external persons are being managed by Judiciary staff. Each of these projects are developments geared to improving how we do business and how we serve you. In the modern, fast-changing world of courts, there are always requests for improvement and enhancement, and our staff must be innovative. Following on the philosophy of Frankiewicz and Premysich, the Department of Court Administration of the Judiciary of Trinidad and Tobago has developed a policy for ICT of nurturing curiosity, harnessing valuable data, and having the skills to translate it into meaningful insights and being able to act on those insights. A policy of pairing technology with the right human skills and investing in adaptability, curiosity, and flexibility.
The commitment to transformation through education was amplified during the 2020-2021 law term and represents yet another example of the agility and resilience of the Judiciary of Trinidad and Tobago. We hear now from the chair of the board of the Judicial Education Institute, the Honorable Justice Lucky.
Amid universal challenges resulting from COVID-19, the Judicial Education Institute of Trinidad and Tobago, JEITT, recalibrated its operations to ensure that our vision of transformation through education continued to be actualized. Under the astute leadership of the President of the JEITT, the Honorable the Chief Justice, effective digital e-learning strategies were employed, allowing us to successfully transition all our in-person training workshops and judicial events to the virtual environment. During the 2020 to 2021 law term, the JEITT was able to reach more than 800 judges, judicial officers, and members of court administration, a 16% increase from the previous year. The JEITT hosted a total of 83 judicial workshops and sessions, an increase of 54% from the previous year. The JEITT continued in its collaboration with local, regional, and international justice sector stakeholders. Training topics included human rights, HIV and the law, competition law, forensic social work and the criminal justice system, case management, and digital evidence. Our 2021 Professional Development Seminar focused on the effective adjudication of financial crimes. Our distinguished jurist lecture explored artificial intelligence and the law. The JEITT now operates at Level 13 Tower D at the International Waterfront, with facilities outfitted with streamlined technology, high-definition capture solutions, and e-learning software. The JEITT celebrates efficacy, growth, and the creation of new opportunities as we continue to embrace the technological future.
So there we are, ladies and gentlemen. All of this has been accomplished in an environment of restricted movement and declining revenues. Releases for our development program decreased from 45.4 million in fiscal 2020 to 33 million last year. We have been able to sustain significant development and actually utilize funds given to us wisely. We have a burn rate of 97%. I believe the judiciary has demonstrated its ability to manage public funds in a cost-effective, efficient, and accountable manner. However, our ability to sustain and accelerate necessary transformations is hampered by the public sector hiring and financing arrangements that are notoriously slow and inefficient and, as I have observed previously, are in some instances incompatible with true judicial independence. I must therefore renew the call for the financial and administrative autonomy promised in the 2015 budget speech. This call goes as far back as 1892. For our colonial forebears had established a commission to look into the functioning of the Registrar's Office in Trinidad. This was the fulcrum on which the judiciary operated, and it was concluded that the registry should have been a closed shop, given the special requirements such as skill sets and the need to retain these skill sets. Nothing has changed since then. Indeed, it has grown worse in the judiciary in respect of our freedom to manage our own affairs. The skill sets necessary for optimal functioning in a judicial environment are often unique and cannot be acquired elsewhere in state employment or in areas like IT in a formal degree program. The fact is that internationally, education is moving more towards modular, buffet-style accretion of skills as job markets and typical career structures evolve. The focus on papers rather than competencies means that I couldn't hire Bill Gates as an IT technician. Criteria for hiring contract workers in the public sector unfairly discount private sector experience. We must do better than that. It takes way too long to hire anybody in the public sector. The approach being adopted by the CPO clearly hampers our ability to retain the necessary agility and flexibility to execute our transformation and emerging mandate. It builds in inefficiencies, does not allow managers to manage, and pays no attention to the fact that the judiciary is a separate arm of state with different needs, different approach and structure. We cannot transform a nation by digitizing archaic processes and adding layers of control. To be clear, the judiciary is not merely engaged in a process of digitization, which is converting data from analog to digital form with no process reform. We are engaged in a process of digitalization, which is leveraging digital enablement to transform our business model and seize value-producing opportunities. If that distinction is internalized across the public sector, there would be a quantum leap in productivity. In that regard, there are some major transformations in store for this year. We begin with the establishment of the Estates Administration Office to replace the probate registry within the Civil Division of the Supreme Court. This will entail a revision of internal processes and staffing assisted by the online authentication of court documents. Online authentication, or e-verification, will extend beyond probate to all court orders and office copies. Another major focus will be the promised small claims court, where we intend to explore online dispute resolution. I'm pleased to announce that despite challenges faced by cash flow and COVID-19, the move to Tower D at the International Waterfront has begun, and some departments are already installed. The movement of the Civil Division of the Supreme Court, including the Court of Appeal, will enable rollout of technology-enabled courtrooms and incorporation of alternative dispute resolution. We will continue the expansion of e-payments, including vouchers, to cover all fines and fees, and together with the profession via the Rules Committee, we propose to simplify the fee structure to avoid multiple filing fees for each case. I have noted the backlog of sexual offense cases and the particular effect that delay, as well as the standard processes and procedures, have on victims. Since legislative provision has already been made for the Rules Committee to create special procedures for case types selected by the Chief Justice, a committee has been convened to draft procedures for the attention of the Rules Committee. We intend to bring a sexual offences court into operation. We will not be neglecting general backlog in civil and criminal matters, and separate committees are being convened for each division. I'm pleased to see that we have begun to get more indictments from the DPP's office, and now that the Honorable Attorney General has announced the switchover date for elimination of preliminary inquiries, we look forward to working closely with the DPP and the Public and Private Defense Bar to achieve a smooth transition. The numbers won't be less, but it is a fantastic opportunity to retool our process with an open mind. Now that we have more experience and data, concerning judge-alone trials, the time is ripe for further discussion about making that a more robust, perhaps even the default option, without eliminating choice as appropriate. I want to pay a special tribute to our staff and judicial officers, many of whom worked impossible hours to make all of this possible. It could not have happened without their extraordinary dedication and commitment. A special tribute is due to our unsung heroes, the medical response team, who kept us going and worked proactively despite the tragic loss of 2 staff members to COVID-19 to keep us and our buildings safe. We can never repay them. There is more, much, much more, but we only have so much time today. I invite you to go online and look at our website to get a further appreciation of what is being accomplished and the continuing enhancement of service. For those of you interested in detailed statistics, our annual report due before the end of the calendar year, and which will also be available online, will be a useful resource. Of course, none of this could have or will be accomplished without the invaluable input from our dedicated team and our external stakeholders, some of whom I have already mentioned. Lists are always dangerous, so I will say a general and heartfelt thank you to all. Most of all, to you, my fellow citizens. Thank you for being patient with us as we strive to manage major transformation during this ongoing pandemic, and for having afforded me the courtesy of your attention today. May God bless our beloved nation.